Thank you, Suzanne. Of course, fill out your evaluation forms. You can fill it out now if you want to, and just list 5 everywhere you are down the road. I'm Tony Capizzi. I am a judge from Montgomery County, Ohio. I'm here with a few different hats on. I'm here, of course, as a juvenile court judge. I'm here as the National Council of Juvenile and Family Court Judges representative to Global Advisory Council, which I'll talk about in a little while. And I'm here because I'm a very strong advocate for issues regarding privacy and information quality. So for the next hour and a half, we're going to spend some time and talk about some key issues. And I'm going to try, by the time we're done with today, for you to be able to understand and or answer these kinds of questions. And at the end, I'm going to try and give you, I'm not a techie. I'm good at what I do, but I'm not really a techie. So I don't have the ability to come in here and put up the website right now and show you what to do. So I'm using some samples. But I'm hopefully going to make it so you understand what it is, so you on your own can do that with your laptops, with your iPads, and whatever you have. But do it after the session and not during the session if you don't mind. Topics today: why should we be worried about privacy information quality issues? I'm going to give you a real short overview about Privacy 101. I'm going to talk about the importance of having a privacy policy within your jurisdictions. What happens if you don't have a privacy policy? How can that affect your jurisdiction, your court? I'm going to go from privacy to information quality, because in many ways, one without the other is a waste of time. You have to make sure what you have is correct information, and we'll talk about that. I'm going to tell you about the resources that I have available here for you to use and what you can do on the website, and finally show you our newest website, information sharing website. That's a lot to do in an hour and a half. I'll take questions along the way if you have them. I've been asked to remind you, if you want to ask a question, that please go to the podium to the speaker, because this is being recorded for future reference, I would assume. So, and if you are from the states of Wisconsin, Ohio, or Wyoming, I'm not picking on you. Through this presentation, I'm going to pick on, but not pick on, 3 states now and maybe 4 states later, and this is my home state. So I want to say to you, I'm not offended. I hope I don't offend you if I pick on your state. There's a headline, 2008. This is the appropriate time to talk about this, because just about 4 years ago in August, there was a director of the Department of Human Services in Ohio, a cabinet-level position, who on behalf of President Obama decided to go online to check in the records of Joe the Plumber. The name you may all remember is Joe the Plumber. He was an Ohio working kind of guy who wasn't paying his child support. And during an Obama presentation, a speech, Joe the Plumber confronted the then president, running for president, and it blew up into a circus, because we found out a few days later that the way that the information regarding Joe the Plumber's personal information about his child support came out was because the director had authorized the search of all of his records in the Ohio Records Bank, and as a result of that, she lost her job. The state of Ohio was embarrassed nationally. There was a lawsuit filed against the state of Ohio, which took 4 years to settle, and in the end, he won no money against the state of Ohio for a legal technical reason. But the reality is, it cost the state of Ohio 4 years of bad publicity. It cost them 4 years of lawyers, and now there's still a negative image on the issue of that information that was disclosed. When you download, if you download my PowerPoint, there's a lot of notes attached to it. So I try not to inundate a PowerPoint with a lot of verbiage. So the slide itself will have minimal stuff on it, but if you download it, there'll be a wealth of information about everything I'm talking about. So virtually for every slide, there's another 2 or 3 pages of explanation that you may use for follow-up. So that was a problem in Ohio. It still is, and we're dealing with it. Talk about this one, August 25th, 2011. This happened to be in the great state of Wisconsin. You have people like this gentleman, who's a state senator, and nothing against elected officials, line one, but I don't get along real well with legislators who don't understand the law whatsoever. So this legislator decided, what my bill does is coordinate the information so law enforcement can get the whole picture of a juvenile who has committed the crime. Forget about privacy. Forget about any information quality issue. It's, I want this to happen, so we're going to just forget about privacy rules, and we're going to pass a bill that forces the judges and forces the courts to give us everything we want. Before I go on, let me ask this question. How many of you are public sector, working for courts, court administrators, clerk of courts, those kinds of individuals? Most of you? All right, looks that way. How many are vendors? Any vendors in the audience today? One? All right, and how about people that work for judges? Any judges or people that work for judges? Work for judges, all right. So, and any other judges besides myself in here? All right, good afternoon, sir. All right, where are you from? You know, you guys have, I think, the largest contingent in the country here. I was pretty impressed by the list of people from Arizona. So this is an issue. It just shows what happens when people don't understand what the laws of privacy are. Here's the third one. This, I think, is amazing out of Wyoming. Headline: One prosecutor's proposal for juvenile justice in Wyoming. Cook County prosecuting attorney proposes including making confidential juvenile court records available to community justice service boards, criminal justice agencies, and public and private entities to supervise the care of minors. So again, a complete disregard of the issues of privacy regarding a juvenile, and it could just as simply be an adult who may be on probation or parole. These are the kind of things that are happening around the country. As we go through different states, I see this happening everywhere. What is privacy? And I give some very simple definitions because this is a 101 course, and later on I'll become a little more complex. But I'm going to start this off in a very simple kind of way and say basically privacy refers to an individual's rights to prevent people from collecting stuff about them. Comes down to that. Inappropriate collection, use, and release of personally identifiable information. PII. That's a phrase I may use a few times. It's personal identifiable information. Your name, your SOCH, date of birth, your DNA type, your fingerprint. Anything like that that can identify you individually from somebody else is a PII. Privacy interests include personal behavior, obviously personal communications, and privacy of personal data. And as a sidelight, I'm sure you know if you work for anybody besides yourself, anything you put on your computer is open knowledge. So if you want to say you love your wife or husband, probably not smart to do it on your state computer if they go looking through your records one of these days, or your girlfriend or boyfriend, whatever, or both. So there's a difference between privacy, civil rights, and civil liberties. You hear these terms thrown out all over the place, and people just sort of mix them all together. And what I would say to you is that civil rights is an affirmative right that you have that the government must support. You have a right to certain freedoms. It includes the right to have your information not disclosed for any reason, theoretically without your approval. So civil rights, they're really positive rights that you have, that the government says you have a right to have this information held secret. It's an affirmative right. Civil liberties are just the opposite. Civil liberties are the rights the government can't take away from you. You have a right of free speech. You have civil liberties that are different. Think of civil rights as a positive right that you have, and civil liberties as something the government can't take away from you. And so when you see all these different lawsuits that are pending, they talk about civil rights, they talk about civil liberties. There is a distinction. And that's all I'm going to say about that. But I think you should realize there is a positive right that you have, which are your civil rights, and then there's the negative thing, which the government can't take away, your civil liberties. Okay. What is a privacy policy? Do any of you know if your courts have privacy policies? Do any of your courts have privacy policies in place? Okay, 3 or 4. We're going to talk about what is a privacy and civil liberties policy, and why do we have these? Why you should consider having them, and I'll show you how to get them. There's a difference between a privacy policy and a security policy. And security policy is you know who uses your IT system. You know who uses your case management system. And you have a security policy in place so nobody can break in and use it. So that's a security issue. You have someone in charge of your security. You have passwords. And so you know your security system is in place so nobody should be able to attack your system. That has nothing to do with the privacy policy. It's night and day. Why do we have a privacy policy? Anybody have an idea? I mean, why do you think we should have a privacy policy? I'll say there's maybe 8 or 10. Can I pull a few out of people? Do you think we should have a privacy policy? Let me start with the basics. Do you think your court should have a privacy policy in place so that information, PII information, personal identifiable information, isn't shared to the wrong people? Does that sound like a logical thing for you to have? All right. And so let's make the assumption that if you don't have one in place, you should consider having one in place. And over the next hour and 15 minutes, I'm going to tell you how to get one, how to look at what you have, see if you need one, how you need to fix it if you have something in place. You may have something in place you don't even understand what it is. And the goal of this presentation is to sort of help you self-assess your court, self-assess your system to see if maybe you can do a better job of having it done. And so, in reality, I think one major purpose for having a policy in place is that, one, you force your agency to adhere to a set of principles and rules about what you think is appropriate and right. Secondly, you create a policy so that the community believes you're doing it the correct way. So that if any of the human rights organizations, legal rights organizations come to you and say, you are violating the civil rights of so-and-so, you can show to them you have in place a policy which assists you in doing that. It's a good PR thing, if nothing else. Anybody think of any other reasons why you would have one? Okay, it creates public trust. Mark? Prevent stolen identity. Thank you. That's one reason why you would have it. You need to have that purpose in place, the reason in place to do it, so you know people will do it. You want to build public trust. So much of what we do, I mean, I'm on the bench every day, except when I'm here. And I have to create, in the image of people who come before my court, some level of fairness and equality. And if, as a court, my court discloses information about a child or an adult, because I handle all those cases of adults who don't pay their child support where they've had a child out of wedlock, which are a lot of cases. I think in Ohio, 55% of children are born out of wedlock. So most people having children, more people having children now who've never got married. In the end, it's the right thing to do. Now, what happens without a privacy policy? Tarnishes an individual's image. It clearly tarnished the director of Ohio. It, as was heard here, invasion of privacy issues. It deals with issues of personal liability. If you disclose information about an individual and it comes back and the court's sued, you may get sued too. Of course, the court has to worry about paying settlements. So often, if you do this, this is what highlights the newspaper story. This is what the TV stations love to show, a mistake, and I'm going to show you a few mistakes in a few minutes. And that means lack of complete public support and confidence. And how many of your courts survive by money coming from a county commission or a city, and you need to have your courts funded, or your offices funded by the state legislature or by your local government body? And I got to deal with my county commissioners every year about my budget. And if I have no public support from the community, I'm not going to get the $100 million or $50 million I may need. That eventually means loss of means and methods goes by the issue of funding. If I break a rule in how I do it, or if a police officer breaks a rule in how he does it, we take away the toys. The police officer that may they have the new license scanners, they use that improperly, there's not proper rules in place on how to use that information, the toy, may be taken away from that police department. Of course, loss of funding. As you lose community support, you lose elected official support, you have funding problems to deal with, And probably the worst is loss of morale, decline of morale, and then getting shut down. I mean, they can't shut me down as a court system. They can kick me out of office. They can't shut me down while I'm working. But a lot of agencies have that problem. What happens without a privacy policy? How many people have ever heard of Governor Rendell? Governor Rendell was the governor of the great state of Pennsylvania. Before the governor became governor, he was the mayor of Philadelphia for about 8 years. Before that, he was the DA in the great city of Philadelphia. He's a very strong-willed individual. And actually, after he left the governor's office, after 2 full terms, he then went on to be the chair of the Democratic Election Commission, Democratic Party. Well, Governor Rendell doesn't like to apologize. About the same time this happened on September 14, 2010, about a month after this, there was a big snowstorm one day in Pennsylvania, in Philadelphia. It was supposed to be a Monday Night Football game. The Minnesota Vikings were supposed to play Philadelphia. NFL moved the game because of the blizzard. And the governor went on the air the next day and called us a nation of wusses. He goes on to say in his statements that in China, and he is free with his words. So he says, China's kicking our ass in everything that we do. If this game was supposed to be played in China, they would be marching to the stadium 4 hours early to cheer for their teams. In our country now, for a football game, which in Green Bay, it's always snowing, there's always a blizzard during a game. How could they literally do that? So Governor Rendell says what he wants to say. And he's very strong-willed and has a great history of involvement with our country. But this man had to apologize. And he had to go on air in September of 2010. Governor Rendell apologizes for terror bulletins on protest. An embarrassed Governor Rendell apologized to groups whose peaceful protests or events, from an animal rights demonstration to a gay and lesbian festival, were the subject of regular anti-terrorism bulletins being distributed by his Homeland Security Director. You'll say, what does that have to do with privacy? What does that have to do with information quality? And what happened was those departments, both state and federal level, did not have in place proper privacy policies, and in addition to that, failed to train those individuals on how to manage what they were doing. And so that created the headline, that created the embarrassment, and I will tell you right now, a number of people under Governor Rendell lost their jobs. So when I go back to that other slide, and I talk about what happened, all these things happened. He lost public support and confidence. They lost some funding because of what happened. He had terrible morale because of what had happened, and a bunch of people lost their jobs. So it can have a major effect on what you do. Here's another one. This is even more interesting. Ever heard of honey-baked ham? Y'all get honey-baked ham for Thanksgiving or something? In 2005, outside of Atlanta, there was a little protest outside of a honey-baked ham store. Vegans were protesting the right of people to buy hams. That's all it was. And the police were hiding out, and I am a very strong supporter of police, so this is not an anti-police presentation, don't believe me. But in this particular case, vegans were targeted for protesting. There was literally a fear at the Atlanta Police Department that there was going to be a riot. And so they had undercover people taking pictures of the vegans who were protesting. Well, an officer, plain clothes, is taking pictures. A woman who's protesting with her husband walks over and says, "What are you taking our pictures for?" And the officer says, "We're taking your pictures because you're protesting." And he identifies himself as a police officer. She says, "You can't do that." And he says, "Yes, I can." And she said something she shouldn't have said to him. He arrested her. And he arrested her husband. They got arrested, and they were charged with multiple crimes because they were protesting outside of a honey-baked ham store. Now, the important point here is that happened in September in 2005, and of course, ACLU on their behalf filed a major lawsuit, sued the federal government, state government, city government, and that case went to trial in federal court 6 years later. It took 6 years of pretrial negotiations, 6 years of exchanging of discovery, 6 years of reviewing all the tapes of what happened at that event, and 6 years later the jury came out in favor of the plaintiffs against all these different government entities. Now, in the end, the jury gave them $1 in compensatory damages and all their attorney's fees. You can imagine the cost of attorney's fees for 6 years. And again, the real negative connotation. This was in the Atlanta papers week after week after week, talking about how these poor people going to protest outside of a honey-baked ham store got arrested, taken downtown, mugshot, the whole deal. And in the end, it didn't cost them a lot of money, but it cost them so much more because of their inability to understand what a privacy policy is, how you implement it, how you train for it, and how you manage it. And so that was a real problem. In addition to issues of privacy, and I touched on this in the very beginning, there's a question of quality of information. When I'm talking about quality, think this over for me with a minute. If your court deals with, and I'll pick on a juvenile first, only because that's what I do most, you have a child whose record's sealed and expunged. And so someone asks for their records, does a records check. And the information is he got his record sealed and expunged last month. He got his record sealed and expunged 3 months ago, whatever, pick a date. And your records have in it that it hasn't been sealed or expunged yet, because your policy on your information quality says, in our court, it is okay to update. Push the refresh button. Is it every week? Is it every 30 days? Is it every 6 months? If you have a divorce case where there's a domestic violence petition filed, do you update your records every day, every 3 days, every 9 days, once a month? Because what happens if the police go out to your home in the middle of the night and they do a records check, or they do a check on the records from the court system, and because you don't put your records up line every day or every week, that woman can't prove she's got a restraining order, and then she's killed. There are example after example of reasons why timeliness is important. Everybody thinks of information quality as meaning, well, someone who put it in, the tech who put it in the computer, put a wrong date in. And that may be true, but that's just one way where that information can be not quality information. Is it too old, the information? Is it from the wrong perspective? And so you have to make policy decisions when you create your privacy policy. You should be making policy decisions on, all right, it's got to be kept private, but how often do we check it to make sure it's correct? 3 major points here. The information, of course, needs to be valid. It has to be reliable, and I'm going to touch on this for a second. And it's got to be timely. And this was pretty darn timely. I was in New Orleans yesterday at a meeting, and I'm going back there tonight to put an all-day workshop on tomorrow for judicial leadership. And as I got to the airport yesterday to come here, I got the New Orleans newspaper, which is called the Times Patacne or something like that. I can't say it right. And on the editorial page of yesterday's paper, Article 1 by a judge, go judge, MCC report too simplistic to be accurate. So information quality issue. The judge is describing how this report that shows the incompetency of the judges at every level in the state of Louisiana is improperly done, and he gives reasons why. And everything he talks about deals with issues of information quality. And then the biggest one, our opinion, this whole article is about follow law on police stops. This article talks about yesterday that police now pick up what are called, they call them FICs, field interview cards. In the city of New Orleans, whenever a police officer stops an individual, they're supposed to ask them questions, get all their background information, name, soc, everything. And since, over the last 12 months, they have done 71,507 field interviews of people on the street. And it's all now in a computer bank. And of those 71,507 field interviews, they arrested 12,860 people. because of the information they've got. Now, what about the other 60,000 who weren't arrested, who shouldn't have been questioned, but because that's the policy in Louisiana, New Orleans, not really, that's what it is. And so this whole article is saying to the police director, hey, guy, what about the privacy rights? What's happening? Do you have a privacy policy in place? Why can you do that? How can you get away with it? And no one's filed suit yet, to the best of my knowledge, but I just saw this in yesterday's paper. And as I was flying here, I thought, this is the perfect example of how current this is. This is going on every day. And it's going on because we have not determined yet, at least in New Orleans, they haven't determined what's a right of privacy. What can the police do and can't do? And it looks like, and he defends it completely. This article, he justifies every aspect of what the city's doing. And there's also another part of this called SARs. They're strategic activity reports. And they are all over the country now, where when a police officer sees something, suspicious activity reports, I'm sorry, SARs, suspicious. When an officer sees something happening, they're supposed to write a report. And it goes into a bank of information now. And I'll give you an example where it really worked. There was a military base in the Carolinas, North Carolina, where they saw a Hertz truck. And when it was at a gate it wasn't supposed to be at, they thought. 2 days later, they saw the same Hertz truck there. And the officer wrote a SAR, Suspicious Activities Report, and they did a check on it through the computer banks all over the country now, because every state has what's called a fusion center now. And that fusion center is an accumulation of all the data collected by police departments around that state. And it flows in for purposes of terrorism, and now it's being used for not just terrorism, it's being used for all types of crime. And they found out from that SAR that, in fact, that truck was scoping it out to blow up the military base. So there's reasons why it happens. But so much of this is the quality of what the information is. Now, if a person narrates what they think they see, I think you know from your experience of being in courts, eyewitnesses are wrong, probably wrong 3 times more than they're right. You ask 10 people what they saw. If you ask 10 people what color tie I'm wearing, in 10 minutes, they probably all have it wrong. And so that information that goes in reports may not always be what we want it to be. How do you develop and create these different protections that I think are necessary for you to have? Don't recreate the wheel, please. Don't waste the time and effort or energy. Federal government, as a result of 9/11, created a FACA, which is a Federal Advisory Council, which I serve on for the U.S. Attorney General. And what we found at 9/11 was that we as a country had a variety of information about what was happening, but didn't bring it together. It didn't tie together anywhere. We knew about the pilots being trained down there. We knew about the money over here, but we didn't know it because it never came together and it was never analyzed. So as a result of that, there was created a FACA, Federal Advisory Board. There are a number of these, but this is the important one that I serve on because it relates to the Attorney General of the United States. We get money from BJA, which I know you know of, and OJP. We do a lot of work with both of those institutions, and they fund major research grants, major research issues around the country. They address the technical and privacy policy issues, and one of the policy issues, of course, is privacy. There are 32 different agencies around the country. We represent 1.2 million justice professionals. And for the last 8 years, I've been on this committee and creating the policy framework for privacy, information quality that you could take off the shelf and pretty much use. And that's the point of this. You don't have to recreate. I'm going to show you the tools to make it work. Within the parameters of what's called the GAC, the committee that I chair is privacy and information quality. So I have focused now for 8 years on the issues of privacy rights of individuals in our country and how to maintain quality of information so that if we use it, how do we use it? Is it accurate? Is it timely? And what can we use it for? So all key points that affect what you do. There are so many tools that we have available for you to consider. But basically, in terms of privacy, we have created a set of documents. And I'm not going to spend much time on this. This is the overall policy rules of what we have. It looks like this little book. It looks really big. I don't want to overwhelm you. That looks like this is that book. So obviously, it's not 3,000 pages. You know, it's something you can read. It's not The Hobbit. It's something that you can read on the way back in the plane. And everything's online here, which you'll find in a minute. But what we figured out, and this is key, no matter what stage you're in terms of privacy and information quality, and I'm going to focus right now on privacy, I've created my committees, and just so you know, two of your members are very actively involved in my committee. Both your president and Alan Carlson, who got your award this morning, are active members in this committee. And so Kevin has been involved now for 2 years, and Alan has been working with me for 8 years. And Alan is one of the smartest individuals I've ever met. And he created many of the backbone policies that all this comes from. But there are different stages, 6 different stages for you to evaluate where you are. I did this with my court. And I'm going to break them down real simple for you. The first one is who makes the decisions? The policymakers. Maybe not you. Maybe the county commissioners. Maybe the state treasurer. Somebody like that. Somebody at the policy level decision-making ability. And so we've created a very simple, 4 pages total, basically a cheat sheet or a dumb it down for the elected officials or the administrators who set the policy, who give you the money. And this is the executive summary on why you need a privacy policy in place, and you use this document to justify what you need and why you need it to present to the policymakers who make the decisions. And also 7 steps to a privacy, civil rights, and civil liberties policy. Really, I mean, this stuff is just like 101 dumbed down. So they can understand it, because clearly elected officials, they have too much to do. I'm not picking on them. I was an elected official for many years myself, and you know, I can't read maybe a 300-page analysis report of what needs to be done. But so give it to me on 2 sides of a sheet of paper, then I'll understand it. So that's what this does do. So stage 1 is if you don't have a privacy policy in place, and let me go back. If you had one in place already, I may say to you, perform an evaluation. I may say, do an annual review. But the way this is, it's circular. Because if you haven't had one, you start at number 1. But if you have one, you may start at 4. It always keeps on evolving. A privacy policy should never be done, and you settle on it, and that's the end of it. You should use it and review it. So again, the first stage is to educate and raise awareness of individuals who make the decision that, yes, we need to proceed and have one put in place. Stage 2, you need to determine, do I need one? What are we doing? Can we make it better? And how will it affect what we do? And so the way these documents have been prepared, they've been prepared for local, state, federal, let's not forget tribal justice entities, which are extremely unique situation, very interesting. And I saw earlier today there was a presentation on tribal issues by one of the judges. So we try and touch every part of government that has any effect or interrelationship with the federal government. Stage 3 is the actual development of the privacy policy itself. I have in the document, there are a number of samples to work from. They show you how to develop it, what templates to use. You compare it, of course, to your own court, to your own city or your own state. You know, we just worked with the state of Indiana to completely do their state level. We worked with Florida, worked with a number of states. And actually, as part of federal government funding now, to get federal funding, you have to have a privacy policy in place. So now there are 49 states who successfully accomplished getting their public policies in place for privacy. Stage 4, form an evaluation. This was the hardest in my own court, and I'll tell you why. People don't want to know if they're doing it wrong, especially when you're an elected official and there's public records checks. When I proposed in my own court having a policy evaluation done, let's see how well we're doing already. Let's see where we are. And I would say to you, some people on my staff said, Judge, we don't want to do that. We don't want the community to know how bad we are if we're bad. And I said, well, we're not bad, but I'm not afraid. Let's find out how to fix it. But that was the biggest complaint I had. When I go around the country, my court did it, and I got the state of New Mexico's juvenile justice system statewide to analyze it. And I got the city of Chicago, their police department, actually two. I had the city of Chicago and I had the state of Illinois state trooper organization. So all four of we were the four guinea pigs. We tested out and created this policy review checklist. And then when you get it in place, after you've figured out what you need, we then deal with implementing. And like anything else, you have to train your staff on what they can and can't do. You have to train, be it the clerks in your clerk's office who can disclose or can't disclose. What can they tell person A about person B? Is there anything they can tell? If someone from Children's Services calls you up your clerk's office and says, I understand John Doe was in front of you for a domestic violence charge, do you have his current address so we can go after him? Can you disclose that information? I'm not going to tell you can or you can't, but I think you need to understand if you can or can't, depending what state you're in. And then if your people don't understand what the rules are, you're in trouble if you don't train them. And as you may have heard earlier, what goes out the least? As budget cuts take place, we don't want to fire staff. So when we run out of money, we stop training who we have. And so you need to understand that training is extremely important. And so there are a whole set of documents here that will assist you in training your staff on how to implement a privacy policy, train those individuals on how to use it and understand it, and then make sure that it's working properly. And step 6, once it's in place, keep on reviewing it. Keep on looking through it to see if there's mistakes. There are other ways to improve it. As the federal laws change, as there are court cases that affect what's happening, we always update all these documents. I just, in 2011, our committee completely updated every single one of these documents. So you'll say, what are we doing this year? Well, as a sidelight, not because it's related to this topic, but if anybody here from Colorado? All right, how about California? Okay, Colorado and California are doing some really neat things that relates to DNA, familiar DNA searching. So we've just created Introduction to Familiar DNA Searching and Justice Agency's use of biometrics. And I'll give you a quick example of what that means. Let's say that, Autumn, let's say do you have a brother? How old's your brother? She has a brother who's 24, and she lives in Montana. Let's say he lives in New York. And for her job, for the state, she has to give a DNA sample now, because for many jobs, you have to prove who you are to make sure you're not a sexual deviant. So you give a DNA sample now. And so she gives a DNA sample as to who she is. Her brother's in New York City, rapes somebody, robs a bank, I don't care. He robs a bank, let's say, and there's a shooting, and some of his blood is dripping. So they get his DNA, and they search his DNA, and they search his DNA in the computer banks, and it doesn't exist. He's never been arrested before. Well, then they look at the DNA around the country, and of the number of marks in DNA identification, let's say if there's 14 marks, they find 8 that match her. So now they know through that DNA search that it's a relative of hers that committed the robbery or committed the rape. And from that, they go and arrest her brother. They do a DNA sample of all the brothers and sisters, and then they got the person that did it. Okay. Can anybody think of a privacy issue involved there? Okay. She gives her DNA to the state of Montana because she wants her job. You can't get a job, police department these days, sometimes agencies, unless you give it an DNA or a fingerprint. Now it's DNA. And so the police will say, or the courts will say, maybe she gave her DNA voluntarily to get her job. And she signed a release that says, here it is, here's my DNA, I want the job. Well, the privacy issue is that a full and final release? Did she release her DNA for the purpose of that job only or for everything? And so that's why my group does the things that we do. Colorado and California have been in the forefront of using this DNA search to do everything. There's a famous rape case, multiple rapes in Colorado, which they use it for to convict an individual. in Colorado, Denver actually got a grant to do DNA searching, male DNA searching for B&Es, breaking and enterings. Now, police never really follow up much because there's not much to do on a breaking and entering case. What they found out when they did this mere DNA searching in Denver with a federal grant was that they got rid of 70% of B&Es because the same people do them. They just can't catch them. They were able to catch them by DNA. So, interesting perspective. From the security, public policy perspective, you want to get rid of B&Es, let's use this new science to do that. But from the privacy perspective, I don't think she really gave up her right to her DNA to a cop in New York City when she was applying for a job in Montana. So those are the kind of issues that we're focusing on that we have to deal with all the time. Every day there's those kinds of issues that come up that are pretty demanding on what we do, and they're going to be hitting you regularly. How they touch your court, how they touch the judges in your community, who knows? Will you have more filings because of it? I don't know the answer to that, but it's possible. Okay. Then I have a separate set of documents in place that deal with information quality series. And these, again, are put together in the same theme. An initial document, which is for decision makers, the CEOs of your organization, the commissioners, to make it work. 9 elements why. Then an assessment tool to see if your records are being properly, are they really quality records? We use this in my court too, and we found some weaknesses. We found a number of weaknesses that we as a court weren't properly assessing what we were doing, and we fixed it. Then there's the Information Quality Program Guide, which is the last one, which is a real thick one, that also helps you figure out how to make it better. These are all tools in place to try and help to make it better. The last thing is really more the IT stuff. I could have brought you all copies of all this stuff, and by the time you had all these assessments, they're pretty big. Everything's available electronically, but what we figured out over the last year because of technology, we have now created a tool, just like a Google. If you go on or you go to a website to buy clothes at Macy's. And we've created the website. It's called The Gist. It's a toolkit. Every single resource, every single document that's been prepared for the last 8 years, actually it's 13 years, but I've been involved for 8, on all these different forms, analysis, templates, everything's available online. But if you don't know what you're looking for, how do you find it? And if you don't know what kind of car you want to go to autotrader.com, see the commercials on TV, the woman sitting there and she puts yellow, sports car, fat tires, and all of a sudden it dwindles down to what she wants. That's what this GIST toolkit is. This is the newest, most modern toy the federal government's created in this area, and we just released this approximately 6 to 8 weeks ago. So that's why Kevin specifically asked me to come now to show you about this new tool. Kevin's like me. I'm not a computer genius. I'm a basic, use my iPad to watch movies, to do emails, and some other basic things. But now I can use this. I can go in it. And there's different ways to use it. You can go into it, and you can either search something, browse it, or use a guide, depending on what you're looking for. So let's go ahead and if you went to the website, right there, here's a screen. And it would be real simple. You either search, you browse, or you guide through to figure out what you want. And you're not sure what you want? Okay. It gives you different things, just like if you go shopping. What kind of car you want? Do you want to look at an overview? Do you want to talk about law enforcement? Are you looking at it from the perspective of a prosecutor, from the courts, from corrections? Because we have a lot of involvement with issues of reentry now, so we have adult parole and probation involved. So all these, are you dealing with homeland security, transportation? We're now working with health and human services. It is a battle every day exchanging information electronically. You're able to call, if you're a clerk, or if you work in a prosecutor's office, you want someone's medical records. You may know the doctor's office. You may know somebody else, make a phone call. But in this day of technology, you don't have time to do that anymore. So you want it electronically. And so places always say to me, I can't disclose medical information because of HIPAA. I can't disclose school information because of FERPA. That is bullcrap. That's their defense and excuse because they don't understand what they are. Those have been put in place to protect people's rights by having proper policy parameters in place. If you know how to use them, all that information is available. But when I used to call a doctor's office and I'd say, I'm handling this case, there's this particular issue, sorry, Judge, we can't disclose it because of HIPAA. I don't think so, and we've been able to fix that. But that's what this does. It gives you a different way to search. You can refine your search any way you want. Here's an example. What are we in? We're in privacy. So you just go to the focus, you say, I want something about privacy. You click privacy, and then it'll give you everything you need. I know this sounds basic, but we didn't have this 6 months ago. We didn't have it 3 months ago. And so when you go to privacy, it'll then show you all the products we have. There's different ways to approach it. And the important thing is it gives you information, and it gives you quality of information because, like I said, our stuff's current. And so if you want what the current federal or state laws are, and I can't tell you it has the current state law for 50 states, but it will tell you, it'll warn you, it'll give you the information, then it'll say in red basically, don't forget to check your local, state, and federal regulations to see if they're different. Some states they are. I want to evaluate and assess my privacy policy. So by a guide, you just go in and say, I want to do something. What do I want to do? I don't know what I want to do. Well, okay, but the point is, this gives you different ways to try and start. If you're on ground zero, you don't know exactly what you want to do, this gives you the ability to try different options. Same thing with this last page of this part of it, where it basically gives you the information. You can go to this website and find out everything that we're doing and how we propose that it's done. I'm not going to spend any time on this because I'm running out of time. I want to talk about cloud computing and give you one more story. You're going to be inundated by a number, if you haven't already, of vendors who are going to tell you the new wave is cloud computing. If you're like me, it sounds really simple, and it sounds like a great idea, but then when you delve into it, there are 3 different kinds of cloud computing technologies. There's purely public, there's semi-public, and there's completely private. And if you're a court or a state that has a private one, it's more expensive. If you have a semi-private one, in other words, they may be holding information from your county or your state in another county or another state. That's cheaper. And if you have a fully public one, then that's much cheaper. So the Amazon.coms, the Googles of the world, they have, I'm sure you realize this, they have all over the world these buildings filled with computer banks. And when you are saying your information in the cloud, it really isn't in a cloud. Okay? There's not some big computer up there in the sky somewhere. All it means is that everything's being held by somebody else. All your information is being held in somebody else's computer somewhere. Okay. Microsoft's never going to go bankrupt. We didn't think GM was going to go bankrupt. Okay? So when you decide to go with cloud computing, you need to make a policy decision as to how do I have access? Is there backup to that information? Is it reliable? Who owns the information? Once you agree to house your information in a cloud computing system, do you still own it? Is it being rented by the Googles of the world? Can they distribute it and use it for their purposes? These are all information questions that need to be made, questioned, answered before you decide if you want to go to cloud computing. I think we're all going to be going to cloud computing. I mean, all email is, all this stuff is cloud computing. I mean, it's all being held by somebody else. And so when you make that decision, and if you have to make the decision because of financial considerations, just understand what questions to ask before you commit to the system you're using. There's some really good vendors out there. Obviously, I don't work for any vendors. There are some really good systems out there in place that I could help you find if you want to. But the point is, don't let any vendor come into your court system or in your clerk's office and say they have the answers. They're not going to tell you what the questions are. They're going to give you answers without the questions. You've got to know the questions to ask. Now, one more sidelight, and then I only have like 5 minutes, and I'm sorry for questions. Oh, 3:15. Oh, good. All right, then I can keep it going. I'm sorry. I thought it was 2:45. All right. When we deal with the issue of cloud computing, I spent all this time, of course, talking about privacy and information quality. Once the information goes into the cloud, who has privacy protection rights? Do you have it? When you give the information online or put it in the cloud, have you authorized Google to let the state of Ohio look at it if she puts it up because she's from the state of Montana? Have all those parameters been written into the plan? Who has access to that information? There's been now for about a year, 18 months, Project Connect, which is between Georgia, Nevada, 4 states on license reader exchange of information. It's in a cloud. The privacy problems associated with just exchanging driver's license is astronomical. Certain states allow you to exchange pictures. Many states don't allow you to exchange pictures. That's the basic question. Question 2 is, but once you put it in a cloud, do you retain any rights over the distribution of that to anywhere? And that's what's going to be hot topic for 2013, 14, and 15. As we try to streamline our organizations, yours just like mine, we have to make these decisions. If you are involved, and I don't know if you're a part of your county or is it the clerk's office, you're separate and apart. But if you're part of your county and the county general administration decides we're going to cloud computing, do you have to go as the court? Are you involved in those discussions? If the state of Ohio tells my court that I got to be part, Stephanie's here and I'm going to pick on her. If OCN, Ohio Courts Network in Ohio, is the accumulation of all local courts' information, docket stuff, do I have to be part of OCN? Yes or no? And if I'm in there, do I have any control over who gets my information? Can I decide that the only people that get my information are other juvenile court judges from around the country, around the state? Or is it open to any clerk's office, not just the judges? There was a great reason to have it, and I'll give you one quick reason why. I'm sitting on my bench. There's 2 children who have come in front of me who have been abused and neglected. And I'm going to ask the parties, because there are 88 counties in Ohio, I'm going to ask the mother and father, ever been involved in the system before? No. If I could go on a system statewide and find out they've had 3 other kids 5 years ago abused, neglect, taken away from them, that will help me in the processing my case. There was a reason to have that information. Timely. Quality's got to be there. It's got to be intact. It's got to be current. So those are issues that will affect what you're doing. And so, again, as the cloud becomes more prevalent and you make those decisions, you can go online to our website and figure out what you may need to ask, how you may need to progress. Now, before I continue, any questions on these issues? And if so, you need to come up to the question thing, the microphone. Okay. We have one in place. You think it's pretty good. You train your staff. Someone sues you. Well, thank God it's in place. Thank God you've had it vetted properly in your community. And your lawyers can use it to defend the organization and the institution. It makes an amazing difference once you've been charged or sued. And as we know in this time of amazing ongoing lawsuits, that we need to protect our institutions, including my court. The most advanced way now to find a person in terms of identification. Some of you people look like you're around my age, but most of you look a lot younger. Anybody remember the old movies, let's say in the 80s, maybe even the 90s, where it could be a James Bond movie or any kind of high-tech for 1980 kind of movie, where they want to go into that that big, secured, underground, government-controlled, secured room. So if you want to go down in the tunnels and you want to get in, you'd walk up to this door, these huge doors, like a bank door, and what would you do? You'd put your eye up against this little thing, and it would do your eye. It would check your iris identification. Remember those movies where they show that? And so James Bond would go up to it, or some famous female star would go up to it and put her eye up there. And now there's all these movies where, I hate to be gory, but they kill somebody, they take their eye, and they use the eye to get into the bank, get into the safe. Well, there are privacy issues involved with that eye. Okay? Today, downtown London, downtown Manhattan, every street corner has on it cameras. Digital cameras, 24/7, reviewing everybody walking down the street. Because technology has gotten to the point where we can now do an iris identification check, which I understand the science behind it. It is better than DNA because it distinguishes twins, and twins, you got the same DNA. So it's actually the most scientifically accurate way in today's world to identify who a person is. Technology today allows us, as an institution, to check and analyze DNA not from here to here, but from 40 yards away. So when there was the bombing underground in London, what they were doing is they were looking at all these tapes of who was going down to the subway. And if you have been arrested before, now they do DNA samples when you're arrested. Pretty soon they're going to start doing iris identification, iris checks. If you went down, they were able to analyze if you were a terrorist because of your iris. And so, again, these are privacy issues that have to be addressed. Now, you may not think they affect you, but they affect the police departments that use your courts. They affect me every day as I see these things happening around the country and those cases come in front of me. When I get a case in front of me and they question the DNA issues, I got to deal with it. There's motions going all over the place. If you as a court, you're not going to start IDing people that walk in your clerk's office by using their iris identification. But the reality is somebody is. And those issues will hit courts sooner rather than later. You need to understand these are all in place. And I think having your court system in place, appropriate privacy guidelines to figure out what to do with it when it hits your court. And so I'm sort of trying to tell you as a preemptive strike, they are, yes, sir. And sir, would you mind, Judge, going to the only because nobody else can hear you? And it's being recorded. And because it's being recorded, yeah. I want you to be famous. Yeah. Go ahead, sir.
You and I both have judicial code of conduct that we have to adhere to. And many of the people in this room are staff members, court administrators, et cetera, which come from courts that have adopted their own judicial employee code of conduct of things that they have to do.
Correct.
And as such, privacy is one of those, as you and I both know, that we can't disclose various things. And they're attributed, much as lawyers are for their staff, to our code of conduct, and they have to act even though they're not us, and they have their own. Part of that is privacy, so they can't release certain things, etc. Which dovetails to what you're talking about, because that's already in place. Now that's a more finite, let's bury down to the bones and say, okay, you can't release this kind of information in this particular case, in this particular fashion. You can't share certain things of that nature. But that backbone for that policy is already in existence for everybody here in this particular room as
Right.
it relates to the court.
Right. Now, what the distinction is now, I think we know that, I'm not saying you or I, but there are court staff who know a police officer, know a lawyer. Somebody calls them and says, hey, my cousin's daughter is dating this guy. Can you do a records check to see if he's good? I've had people call me and ask me that. I've, of course, always said no, but obviously other people say yes, because that's why they keep doing it. And what this does is now, the key to this is that everything is being done electronically. So in the old days, 2 years ago, We would make copies of everything. We would make copies, we give it to people. Now it's all being done electronically. And so once that relationship where you and I know we can't do it, and this will never stop the criminals that do it, I won't say criminal, a bad judge or a bad clerk. But still, it's happening so much quicker than it used to. That phone call doesn't happen anymore. Someone calls you or someone sends you an email and say, can I have a copy of Mary's daughter's boyfriend's traffic record or his adult criminal record? Someone just pushes the button now and it goes.
But see, the thing is, that's fine. And it's not fine, but it's fine. Right. But if you don't have, you may have the policy in place. The policy is fine because it's sitting on the shelf and everything else.
Right.
But if you don't have an ongoing conversation about what is your ethical duty and what is your constraints in this job, then whatever policy you have on the shelf really doesn't matter.
Okay. What this takes to the next level, because you have the policy in place, and then the software is created, and maybe I missed that point, and I'm sorry for that. We create a verbal policy. We know what the ethical guidelines are for what we do, and that's all policy in place. And then now, this system allows you to turn that policy into software, which does it electronically. So you create the policy, you put it into the system electronically, so therefore people who want to break by the phone call, they can't do it because the system's in place in the system. So when they say, I'm going to send you a copy of this, that, and this, the system doesn't let them do it.
All right, that's an authorization.
Yeah, it is, but it goes ahead and creates the software that allows this to be done probably better than we can do it humanly possible.
I like humans.
I mean, I understand, but you know, you're you. We're talking about 50 million people.
No, I understand that, but see, the thing is that just as you said, with cloud computing, all right, you don't know who controls what and everything else. You know, as you know, there's systems known as Echelon and Carnivore, all right, that can steal and get everything. Well, the same thing, somebody can get that information any way they want and not go through the proper channels, and then we'll have no way of knowing about that.
Right. The criminal side is a problem that we all have to address, but that deals with my concept of security. That's a security problem. Once you have it, you have to make sure it's secure, and how you manage that's a different issue than having in place the policies originally on what's protected and what's not. Okay. It was a great discussion, Judge. Thank you. Judges are always outgoing, and they say whatever they want to say, and they get the conversation going. Does anybody else wish to ask a question or raise a debate as it relates to privacy and information quality? Do any of you have in place a policy that you know how often you update the information in your computer systems? Do you require your staff to review information at any time? If it's put in the first time, is it just, that's it? Doesn't get reviewed, doesn't get updated, doesn't get analyzed as to should it change? What about, I mean, and I'm not talking about 9 months later you get another piece of information, because that's not reviewing your old, that's just putting a new one in. Talking about, does anybody review the information you have to make sure it's accurate? All right, you're basically all in clerks of courts. Is it fair to say that an adult picks up a criminal charge? You docket that charge. Does anybody analyze that case to see if it's been updated 3 months later? Does it just sit there? Anybody know? Okay.
It's updated if there's activity.
Right, if there's activity, but that's the only reason when it is. So if my court, what state are you in? You're from Orlando. So if my court, if my bailiff calls your office and says, Judge Capizzi has on his docket today a case from Orlando, and we note that there's an address for John Doe who's the father of this child. Would your records tell you, yes, you can tell Judge Capizzi that the guy's address is blank date effective last week, or just the last time that guy was in your court?
The last time we had information that updated that.
All right.
We wouldn't go out and proactively
Okay.
do a database check to
No.
make sure that that's correct.
Did I get that because of the phone call from my clerk, my bailiff? I mean, how do you know my bailiff is the bailiff and not an ex-wife of that guy saying, I work for Judge Capizzi in Ohio, give me this information? Do you have a policy in place as to what can be disclosed over the phone to anybody?
We're in Florida. Pretty much
Everything's open. Okay. Well, that's a...
now we're mandated to redact. So
Okay.
it's available pretty much now.
All right. You know, there's all these different challenges, and I can't tell you I have the answers. What I am showing you is that there's ways to figure out what the answers can be for you. And that's really where the heart of this goes. As you look through all this stuff and you decide, when you go back and you say to yourself, let's go back. When you're looking at what you need to do. And as the judge says, we all are under different ethical codes already. I would say to you that's not good enough. I would say to you that we can't control everybody who works under us, and we clearly don't train them as well as we should. And so, in the end, the process being done electronically helps deal with those situations you can't see it every day. My court gets inundated. I mean, I'm not a big court. I have 600,000 people in my community, 650 in my community. I always say I have 130 constituents. I have 130,000 children who are affected by my court. And I'm having 26,000 cases filed a year in my court. I know I'm not looking at every single one of them. I know my staff, somebody's looking at something. But we don't have in place, even now, all the appropriate safeguards to disclose. We have lawyers that call my office. I'll give another example. A lawyer calls the office on a civil suit. Calls the clerk's office. My clerk of courts calls me all the time. Lawyer John Smith called our office. They want us to disclose there's a civil suit because of a car accident. They want us to disclose the records of a juvenile that he admitted or denied to the traffic violation. They admit to a reckless act or a DUI. And if that lawyer knows somebody somewhere on a personal basis, they're going to probably get that information, although in Ohio, that can't be disclosed. But I would say to you probably 8 out of 10 times that lawyer knows somebody, and what happens is the ones that come to me are when the clerk's office calls me because some guy, a lawyer from out of state or out of my county has made the phone call. I would say, although I trust my staff, my personal staff immensely, I got 450 staff. If one local lawyer who's in my court 4 days a week makes that phone call, I bet you I never hear about it. All right? It just happens. So in many ways, and I know electronically doing it isn't the perfect way to do it, and maybe if there's a criminal abuse, it's going to happen anyways, but this gets rid of so much of the thinking process of it. Once you determine what the policies are, you put them in place, then the changes happen, and pretty much happen automatically and electronically. And you set up the appropriate firewalls. You know, there's just, we now allow, because of my drug court, I have allowed my mental health providers full access to my case management system. Okay? I have a drugs professional who doesn't work for my court, who obviously is in another building, and they want records about a kid in my drug court. They have access to all those records. Now, in return, I have immediate access to all their records on that child. And so when I go into my court, I have in front of me not only all my court's records, but I have all the records of the mental health provider. Now, of course, there's been releases signed, so that can be done. But the reality is that exchange of information is what I'm talking about. There's that electronic exchange of information that opens up the possibility to exchange information. And how do you control that? How do I control in my system that the only people that can see it are that doctor's office or that mental health provider? You know, we can do that electronically now. And that's what the purpose of this is to limit as you extend or enlarge your approaches. And, you know, when we had the, early on, when we had that comment about let's everybody have access to everything, making confidential juvenile court records available to basically everybody that allegedly affects that child, it can be done, and it can be done by way of protecting rights. And my point is, if you're going to do it so you're not sued, so you're not embarrassed, you don't lose the morale, you don't have all the problems associated with doing it improperly, so that these kinds of things, the lawsuits that I showed you after this, don't happen again. So that's the difference here. By doing it in a proven manner that's been vetted all over the country, we have taken out all the mistakes that were made over the last 10 or 15 years. Maybe that's the best way to describe this. You're going to have a privacy policy in place going into the future. How do you start to create one? How do you assess what needs to be in it? How do you do a check to make sure you put everything in it that needs to be in it? And how do you assess its success within your system? And how do you review it? Those are all questions that have been asked. Answers have been created. Solutions have been vetted. And we've made changes. When the state of New Mexico worked with me to analyze their whole state juvenile justice system, we found some glaring mistakes. When we did my court, we found some interesting, quirky kind of mistakes. When we did the Illinois State Police, it's amazing how many, again, different but similar mistakes. They're all the same. And so don't recreate it. Look at these products, see if they can help you. I don't want to disclose. I'm in a very particular position. I'm not just a judge, I'm a juvenile court judge. And so I have responsibilities that in many adult courts don't happen very often. In many cases, I'm that child's parent. When a child's in my detention facility, I am the parent for that child. When the detective calls and says, "Judge, we would like to interview that child on 3 B&Es. Can we interview that child?" They don't ask the parent. They ask me because they're in my building, and therefore I'm their parent. When I have a child that picks up cases whose records are sealed and expunged 3 years later, in Ohio it's 2 years later, 2 years after the last event, or a certain time after they turn 18, I'm supposed to be protecting that child's privacy rights. It is my job, one of my jobs, to make sure that that record gets sealed and expunged. Now, in reality, how do I do that? I send every police organization and agency a copy of my entry that says, "Take them out of your system." What about the DNA that was taken of that child when they were 17 doing a B&E? My order is supposed to fix that. I don't believe that's happening in Ohio or anywhere else. I have kids come to me when they're 23 and say, "Your Honor," I had a kid this week, last week, come to me and say, "Your Honor, I want to join the military. I have a theft case on my record from 5 years ago. I can't get it off my record." Well, I can seal it. I did last week. And I said to him, "Now, I hope that means you get in the military." I sealed and expunged it. It's supposed to be gone from your record. And because of the privacy issues involved, I'm not going to tell you who, but the reality is that's part of what I do. That's how I protect someone's privacy rights. They're personal, identifiable information. And if I can do that, I'm successfully managing my job. If I'm not doing it, and you're not doing it if you're under me, I'm going to get ticked. All right? When I have those children in front of me, or I have parents in front of me, if I have Joe the Plumber situation in front of me, where we are doing, we had a very high-profile case last summer. The woman was on the Today Show, Good Morning America, I don't think 60 Minutes. It was a case on an adoption, where a woman from California adopted a child out of my county. And we were now 18 months later, and the grandmother of the infant, on the biological father's side, filed for custody. And we went through a 2-year battle over where that child could live, and we were trying to protect the rights, the privacy rights of people. And I turn on the TV in the morning on a Today Show with Matt Lauer, is this woman from California who's decided to use the media to win custody of her child from my court. and you say to people, there's a gag order out here, you can't do it, well, the damage was already done. And so then all of a sudden we had NBC, ABC, everybody was there, CNN. And we dealt with that for a long time. So, Judge, no matter what we do to protect it, people still just screwed up anyways. I'm not saying it's our fault, because in that case it wasn't our fault. And I've done these terrible murder rape cases where I do everything I can to keep the records sealed and keep the identity of the victim as well as the defendants held secret until they're adjudicated. Yeah. Right. Sure. That's right. We kept everybody in chambers. We did everything in chambers. They walk out the front door. Defense counsel in the media has his young man client there. And you're right. It gets out there, but we still have to make sure our staff and our county, our system, exchange it properly and follow our rules. So I guess the reality is we create the rules, however we do it. And I'm saying to you, I don't think ethical issues are enough. There's other reasons and more reasons why we need to do what we do. And as we create the policies, we then turn it over to IT people, who use the information, the policy guidelines we've given them to create the IT procedures necessary to implement them into the system so that it isn't as simple as trusting everybody to do it the right way. That's all. Yes, ma'am. And I know he's got away with it, but he's a judge. So I'm going to ask everybody else to go to the...
Maureen Hafner, Broward County Teen Court.
I'm sorry, say that again?
Maureen Hafner, Broward County Teen Court.
Okay, Teen Court.
I have a lot of kids who finish our program and they file for the expunction, okay, but their records are sold in the meantime, okay, by the FDLE. What security?
See, and they should never be sold. That's part of the policy. That's the policy that has to be made. And so obviously whoever is doing this has already made the policy to sell those, which I think is completely inappropriate and close to being illegal for a juvenile.
Yeah.
But if you set a policy in place, you think about all those questions ahead of time. That's the kind of question that's asked. And when you look to the assessment tool and say, we spent months bringing judges, lawyers from all over the country in place to try and take a day in time. We dealt with an arraignment. But what happens on arraignment day? What happens on the charge day, pretrial day, and for every court touch day, we analyzed and asked all the questions that need to be dealt with regarding disclosure. Right. And that's why that kind of stuff is in there. But yeah, once it's sold, it's gone.
I mean, we're doing everything right to protect the child.
Right.
Okay. But then the families come back and there's no recourse for them at all.
There's none. And that, again, deals with when I talked about the mention of having public policy, having the public support and belief that it's being done right. If the public doesn't trust you, there was I heard an interesting example from in Texas where a court decided to have an amnesty day. And so the judges announced this great amnesty day, and it happened to do with juveniles, where all these outstanding warrants are out, which way too many outstanding warrants. So it could be adult court or juvenile court. They worked with the police department, with the clerk's office, with the court, and said, we're going to open up a community center on a Saturday. Have you all come in. If you got a warrant, we want to arrest you. You'll come in, tell us who you are. We'll book you there right there. The judge will be there to sign, get rid of the warrant, and then you'll be scheduled to appear another day. It was really an amnesty program. It worked fantastically. And I think they told me they had like 186 outstanding warrants, and over 100 people showed up that given day, and they got rid of all those things. And every single one of those that showed up the following week, and the case kept going. It was perfect. Well, they did that, and then this year, right, it was 2011 and 2012, they were going to do the same thing. They announced, because it was so successful the year before, they announced another amnesty program. And the week before the program was announced, they didn't communicate this very well, the sheriff had a sting operation for guys and women who weren't paying child support. It was come in for this reason, and they all got arrested in this thing. And so the judge was telling me how they had this date all set up. They started getting phone calls from parents saying, is this a sting? This is a sting. We saw in the paper last week the county did a sting. And so it was too late to stop it. Less than 10 people showed up with their kids. And so again, it was the community lost faith. There was a breach of privacy, or in that case, it was a communication breach between the court system and the sheriff's office. But the reality is, in the end, it affected community support for this program. And by that breach of privacy, whatever you want to call it, by that breach of information, it was a failed project. And they think they can never do it again because they don't think they can get back the community support that they wanted. So did it have a detrimental effect? It sure did. And it eventually affected everything they're doing in Texas. So this happens all over the country, but I think we have found ways to not solve the problem, but maybe help you look for ways to understand what the problems are in real specific types of questions and issues, and then maybe give you some ways to look at solutions. And if you're completely lost through everything we've talked about, because it's really complex stuff, in the end, and I don't know any way to get to the last few slides unless I do it all over again, in the end, the purpose of this newest document, this newest website, the GIST site, is to just say, you know what, you get home. Judge Capizzi talked about privacy issues. He talked about my court and the clerk's office. He talked about that issue with the honey-baked ham. He talked about the DNA stuff. I'm nosy. I'm curious. I want to protect my court, my clerk's office. I don't remember it all. What can I do? You can go to the website and do a search. Privacy. Search DNA testing. Whatever you think about. Iris identification. If you want to check something out, see if I was telling the truth. Just a basic, is this like one of these campaign ads? 100% true, 10% true, whatever. I'm going crazy now with this new TV ad about one presidential candidate who says that one presidential person is lying about everything, and halfway through the ad, there's a 4-year ago presidential candidate says, oh my God, blank, blank, you should be embarrassed or this because of that. Okay? I remember that ad. I remember her saying that 4 years ago, and I'm amazed how it's being used now. But that again, if that's all you remember, search it. Any more questions? Yes, ma'am. And if you wouldn't mind, come up to the podium.
Yeah, I was hoping that you could just revisit your definitions, if you could clarify the definitions for those 3 fundamental terms that you talked about at the beginning of your session, and then what are the differences between each of those terms of privacy, civil rights, and civil liberties? Thank you. Okay.
There are, as I described in the beginning, there are definitions for privacy, civil liberties. Let me go back to it. And rights are rights that we have that have been given to us, that are rights that are positive. We have the right, we are guaranteed the right of sexuality. We're guaranteed the right to do what we do no matter what race we are. These are civil rights that we have because of who we are. They are a positive type of right that we have. A civil liberty, positive. It's, the government has an obligation to support our right to privacy. Okay? Whereas a civil liberty, that is different. It's almost a negative. They have to make sure they don't take away that right to us. So there is if you spend time looking at the ACLU in their lawsuits, they focus both on civil rights and they focus on civil liberties, but they're managed differently and they're understood differently. A civil liberty is something we have that the government cannot take away. In that regard, civil liberties restrict governments. Maybe that's the simplistic way to say it as a negative, because a civil liberty is what we have, and the government can't say, I'm taking it away. And so that restricts what a government can do. A government can't tell us in the United States we can't speak out. The freedom of speech. That's a civil liberty. We don't have a right to talk. We have a liberty to talk, and it's a liberty that is given to us that the government cannot restrict.
So freedom of speech.
Freedom of speech.
Liberty, not a civil right.
Correct. I'm sorry. Freedom of speech is a civil liberty. Right to a fair trial. It's a right that's been given to us by the Constitution that the state government can't take away. Whereas a civil right is something we have simply because of who we are, the privilege of citizenship in our country. Someone from Europe may have a civil right, but not in the United States. They have civil liberties. They're not a citizen of the United States. And those are the two definitions. And then I talked about the policy, and then my other definition was privacy policy versus security policy. The security policy is a policy in place where you determine who has access to and who's restricted from use of your whatever rules that you put in place. It's you have a security policy in place, as the judge mentioned, so nobody can steal your IT information. You've built up the firewalls. Yes, sir.
Are those broadly defined or narrowly defined?
These are broadly defined here. Within a privacy policy, you should have a security policy. So the privacy policy is an umbrella of all the issues that relate to privacy. You want a policy on training, you want a policy on security, you want a variety of types of policies. A security policy is very specific. That just deals with the aspect of who has access, who can get in, who can get out. What firewalls are created. Are you creating an IT situation where you are allowing your directors and managers to get into it, but not line staff? There's a policy there. The policy is, I only want my directors and my managers to see this level of information. That's the policy. And the security policy is that, okay, how do I implement that? How do I create the firewall, the wall between director, manager, and line staff? So you set up a security policy to break it, to create it, but the overall policy is that I've decided in my court, I think my directors have a right to see something, but not my line staff. I don't want probation officers in my court to see what the director of finance has. But I'll let the director of finance look at the director of probation. So you create different levels, and that's the policy decision. So much of this, when you create the policy, privacy policy, it's all decision making. It's setting the policy from which then you then implement it. And so it's hard work. But we've done so much of it that I think if you look at the materials online, you'll find out there are questions that when you read them, you would say, I should have thought of that. But I bet you 50% of them you wouldn't think of, and I wouldn't have thought of. I mean, I have learned so much in 8 years about issues that I was a novice on because I've been able to manage very, very smart people who've told me how to fix it. And that's what it is. You know, I'm good at running groups. I'm good at managing smart people. And that's the skill I have. I'm not the techie. So I bring all these amazing people together, like Kevin Bowling, who was back there, and Alan Carlson, and they're on the ground floor. I mean, they see it every day. They see the problems. They know which question to ask. I can answer every question, or at least I can create the questions from a judge's perspective. I can't create the questions from a court administrator perspective. I can't understand the problem of the probation officer until they sit with me and explain to me what the problems are. What problem are they having getting access to information? And so that's what we've sort of done for you. We've taken the experiment, we've tested it, it's been vetted, and now there's a product. The product, I'm proud to say, is pretty darn good. And so give it a chance. And if not you, maybe somebody else in your organization. If you got a techie guy or woman, they want to see some neat stuff, they can go on the website and they can search at the highest level of IT. I didn't even touch the techie side. I just touched the policy side. There's a whole other set of same website. All the techie stuff is there too. So again, I want to thank you for the opportunity to come. At the end of this thing, and I know it's online, is my information. And if you have any questions that I can answer after you've tried it and you want to play with it or ask me more questions, feel free to give me a call. Again, I'm not the techie person. So if you send me a technical question, I'm going to refer it to somebody else. But again, thanks for coming today. I appreciate it. Thank you. And fill out your yellow forms, please. Okay.